All right, welcome everyone. Good afternoon or good morning, and happy Friday, wherever you may be joining us from. I'm Sarah Lee, Director of Research and Programs here at the Center for Survivor Agency and Justice, and just want to welcome you to today's webinar, Debt in the Context of Safety, Coerced Debt and Debt Defense for Survivors. I'm joined by Erica Sussman, CSAJ's founder and executive director, as well as a whole panel of amazing expertise that we have for you today, and are thrilled to be joining in this conversation with all of you. So as folks are trickling in and getting settled, I'm just going to go through a little bit of housekeeping to get us on our way. But we have a lot to cover, so I'm going to try to make it quick. Just so everyone knows, this webinar is being recorded and will be available on CSAJ's website, likely next Monday or Tuesday. Check us out at our website at csaj.org/webinars. As registrants, you will also receive a direct email from me when everything has gone live, so look for that. Just to orient you, I'm not going to go through everything. I just encourage you to play around. Ask questions through the Q&A. In the lower right-hand toolbar, there's a little word bubble icon. If you click on that, you should be able to chat me, the host, directly if you have any technical difficulties or issues that come up. I also encourage you to talk amongst each other. We've got a ton of folks coming from around the country. Right now, there are 71 folks in the room and counting, and we had around 270 people register. So I know that there's a lot of attention and interest in this. So as you kind of get familiar, let's practice a little bit. Introduce yourselves to us and to each other. Who are you? Where are you coming from? And what perspective are you bringing to this webinar today? What are you interested in? And feel free to find out what's happening in Minnesota, Oregon, or Mississippi, or wherever it is that you're coming to us from today, and some of the issues you might be seeing and dealing with. So as that is coming through, I'm just seeing one little note that folks are interested in listening via their computer. There should be that option if you go to your quick start to log in and listen via the computer. If that is not available, you may have to call in on a separate line, which often gives a little bit better sound quality. So if you continue having issues with that, I'll follow up with you folks as we get started. I am not going to do justice to these introductions, but we have posted the bios of all of our faculty who are joining us today, and I encourage you to look at their amazingness and everything that they're doing. We are led today by some amazing faculty: Adrienne Adams, who's a professor at Michigan State University; Angela Littwin, who's also a professor with the University of Texas School of Law, and together they've done separately and together, they've done a lot of amazing work looking at the role and impact of economic abuse, particularly debt and credit issues. We also have Ariana Lindermayer, who's a staff attorney with MFY Legal Services here in New York City, as well as Matt Schedler, who's a supervising attorney with Canva Legal Services, also here in New York. And they are amazing on-the-ground experts doing this work in litigation with survivors, as well as engaged in some pretty impressive systems advocacy that they're going to talk to you about. So again, that does not do them justice at all. Take a look at who they are and ask us questions. And I am glad that everyone is joining us. So with that, I am going to hand it over to Erica to help situate us and move us into this presentation. So Erica, I'm going to give you control.
Thank you so much, Sarah, and thanks everybody for joining us today. As Sarah mentioned, we have a huge number of participants with very diverse expertise and from very diverse geographic locations and communities and organizational contexts. So it's very exciting to have all of you with us today to think about a topic that is one that is clearly in need of attention and really is in a place of largely uncharted territory for many of us. And so we do see today as the beginning of a hopefully very exciting conversation around what we know as it relates to coerced debt, and also what strategies may exist in practice right now, and might we be able to devise in the future to really change the landscape for domestic violence survivors. I want to chat with you a little bit about the Center for Survivor Agency and Justice, and more specifically about the project that this webinar is a part of. And then I will very quickly hand the program over to our esteemed faculty, because there is a lot to talk about. CSAJ is a national organization. Our vision and mission are very closely tied to one another. CSAJ envisions a world where all people have equal access to physical safety, economic security, and human dignity. And our mission is focused on getting closer to that vision. Specifically, CSAJ promotes advocacy approaches that are aimed to remove systemic barriers, enhance organizational responses, and improve professional practices to meet the self-defined needs of domestic and sexual violence survivors. A project that we have been working on for many years now is called the Consumer Rights for Domestic and Sexual Violence Survivors Initiative, and this webinar conversation today is part of this initiative. It is a national project that enhances economic justice for survivors by building the capacity of lawyers and advocates to provide consumer and economic civil legal advocacy and to engage in systems advocacy to remove barriers. This project began back in 2007. It was really came out of a recognition that there was a large gap in expertise specifically focused on meeting the economic and consumer rights of survivors. And it was launched in 2007 with some funding through OVC, and it has been a technical assistance project funded through the Office on Violence Against Women since 2011. Our work is really rooted in the expertise of our partners and our expert advisors, all of whom are located in different organizations across the country who are doing work on the ground with survivors every day. And so the richness of what comes out of webinars like the one today, as well as other technical assistance efforts, is really all due to the unbelievable expertise of these partners and individual consultants that we work with. Some of them include the National Consumer Law Center, Home Free, which is based out of Oregon, the Center for Court Innovation, Wider Opportunities for Women, as well as individual experts who hold expertise at the intersection of a variety of consumer rights and domestic violence advocacy-related issues. This is an overview of our program activities. I'm not going to get into them in depth, but I really urge you to refer to our website where you can learn more about each of these things, such as our guidebook and advocacy briefs, practice webinars like the ones that we're hosting today. We have recordings of all of them available to you for you to explore on your own time. Individual technical assistance, so we often receive requests from lawyers, advocates, coalitions, communities across the country that want to problem solve, and we're able to assist with that. And lastly, but certainly not least, is the work of our demonstration sites, a handful of really unbelievably innovative organizations and communities across the country that are very deliberately engaged in addressing the economic security needs of survivors. All of them are listed here, and you can also learn some more about their work by exploring our website or reaching out to us at some point. So without further ado, I am going to hand over today's webinar to Adrienne Adams.
Thank you very much, Erica. I want to echo Sarah and Erica's welcome to all of you. Thank you so much for joining us today. We are going to cover, excuse me, 4 main topics. First, excuse me, I'm going to give some background on domestic violence in general and economic abuse specifically in order to provide context for our discussion of the topic at hand, coerced debt. Then Angie and I will talk about defining and identifying coerced debt, and Matt and Ariana will discuss legal remedies for addressing coerced debt. We're going to have plenty of time for questions and discussion. Really, our goal here is for all of us to learn more about coerced debt and how to help survivors overcome this particular barrier to safety. So beginning with some background. It's been estimated that 1 in 4 women are physically assaulted by an intimate partner annually. Now, this statistic, it captures the physical assaults, but we know that physical violence is just one component of the violence that many women experience in their relationship. Intimate partner abuse is a pattern of abusive behavior used by one partner to gain and maintain power and control over another intimate partner. Overwhelmingly, this form of abuse is committed by men against their female partners, and that's not to say that women can't perpetrate abuse, but for our purposes here and the work that Angie and I are doing, we use the pronoun she to refer to survivors and he to refer to abusers. So that's the language you'll be hearing us use. So I'm sure that this is familiar to many of you. This is the power and control wheel. I began my work in a domestic violence shelter as an advocate, and this was one of the first things I was handed and used throughout my work, and even as a researcher to this date, I still rely on this framework. It's essentially a framework for understanding the system of abusive behaviors used by batterers to gain and maintain power and control in their relationship. So physical violence is captured on the outside of the wheel, that black area. And the various other forms of abuse are displayed as the spokes of the wheel. As you can see, in addition to physical violence, abusers use coercion and threats, intimidation, emotional abuse, isolation. They minimize, deny, and blame the victim for the abuse. They use their children to control and hurt their partners. And they also use gender privilege. So, for example, using, I guess that's essentially using your status as a man, for example, to legitimate demands and threats. So, like, I make the rules in the house, you're going to follow them or else, that kind of thing. Finally, abusers use economic abuse. And this is the piece of the wheel that our work focuses on and that we'll be talking about today. Economic abuse has been defined by the National Coalition Against Domestic Violence as it's when batterers control victims' finances to prevent them from accessing resources, working or maintaining control of earnings, achieving self-sufficiency, and gaining financial independence. And that financial independence piece, I think, is a really big key to this. Economic abuse is an instrument to keep somebody trapped in an abusive relationships a lot of times, and that's what's reflected here. So a few years ago, I, along with 3 colleagues from MSU, conducted a study with 103 women seeking services from domestic violence shelters. We talked to them about their experiences of abuse, and what we found was that 100% of them had experienced psychological abuse in their abusive relationship. 98% of them had experienced physical abuse, and 99% of them had experienced economic abuse. So the study showed that economic abuse was just as common in these relationships as physical and psychological abuse, the types of abuse that tend to get more attention and focus. So the study also showed that there are two components or dimensions to economic abuse. They're what we call, or what we are calling, financial restriction and financial exploitation. Financial restriction involves three primary sets of tactics. First, abusers restrict income generation. So they do this by forbidding their partners to work or sabotaging their efforts to earn money through employment. That might look like sabotaging the car so she can't get to work, calling her and harassing her at work, keeping her from going to work through various means. So these are just some examples. Second, abusers restrict their partner's use of money or property, things like forcing their partners to hand over their paycheck or other money, dictating when and how money is spent, preventing them from accessing bank accounts or preventing them from using a vehicle or some other form of property. And then third, abusers restrict access to financial information. A couple of common ways that we know that batterers do this is by intercepting the mail or hiding bank statements or bills, or if they have online accounts, keeping their partner from having access to those online accounts. So the second dimension is exploitation. Financial exploitation involves unfairly using another's resources for one's own advantage. There are three key ways that abusers do this. First, they exploit their partners by spending their money. I can't tell you how many times I've heard women talk about how their abusers demanded that they essentially finance their life using her income. The second way is stealing money or property. That's pretty self-explanatory. And then the third is exploiting their partners through generating debt in their names. And this third piece, generating debt, this is what we're here to focus on today, abuser-generated debt, which we refer to as coerced debt. So what we know about coerced debt comes from four primary sources. The original economic abuse study that I did with my colleagues at MSU, which is published in the journal Violence Against Women. Angie's study of domestic violence professionals that's published in the California Law Review. And Angie and I are conducting in-depth interviews with coerced debt survivors. We have conducted 14 interviews to date, and that's an ongoing project. And then Angie and we conducted a survey with the National Domestic Violence Hotline, which we are currently in the process of writing up for dissemination. So we're going to draw on all of these projects in some way here in our conversation with you all today, but the majority of the data that we're going to present is going to come from the National Domestic Violence Hotline survey. So I want to very briefly just describe the study methods. So this was a 10-question survey about coerced debt and its effects. We designed the survey in collaboration with the staff at the hotline and then trained them to administer the survey to callers who were willing and able to participate. We had a final sample of 1,816 English-speaking female callers who were over the age of 18. Just a couple of demographic pieces of information for you. As you can see here in this graph, the majority fell within the age range of 25 to 45. So those two longer lines in the middle, that's about 66% of the sample fall within those age ranges. 47% identified as white, 23% identified as black, and 18% identified as Hispanic. Like I said, very brief introduction to that study. So collectively, across all of the studies that we have done, what our research shows is that abusers generate debt in their partner's names in two primary ways. They do this by first obtaining credit in a partner's name, so that might be a mortgage, student loans, personal loans, car loans, credit cards, payday loans, and I'm sure any number of other types of credit. And they also do this by putting bills in their partner's name, so household bills, things like utilities, the phone, cable, rent, those kinds of things. And these actions are what lead to coerced debt. So I'm going to turn it over to Angie to talk about defining coerced debt.
Thank you, Adrienne. Yes, thank you, Adrienne. And thank you, everybody, for attending this webinar. We are very excited to be presenting our research to you and hope to learn from your questions as well. So we define coerced debt as any non-consensual credit-related transaction that occurs within an abusive intimate relationship. Reason we define it so broadly, right? This definition encompasses debt generated by fraud as well as by coercion. We recognize that this is a different framework than, for example, what one would use in a legal setting. The reason we define it so broadly is that because it is debt generated within the context of coercive control, right? Abusers maintain power in the relationship by placing demands on their partner and enforcing those demands with threats and surveillance. They make demands about all kinds of things: what she can wear, who she can see, when she can leave the house, what she cooks, or how she cares for the kids. And they enforce these demands with all kinds of threats, right, ranging from saying something mean to physically hurting a survivor or someone that she loves. There are three ways that coercive control is used to hurt women financially. The first is that abusers use coercion, right, to dictate financial behavior. For example, hand over your paycheck or else, or use your credit card to buy me that TV or else. The second way is that financial harm can result from non-compliance with other demands. For example, not giving her money for food because she did not cook the quote-unquote right thing for dinner, or causing her to lose housing for a reason because she did not comply with an abuser's demand. And then finally, third, the perpetual tacit threat of harm prevents her from taking action when his behavior threatens her financial well-being. It means that she does or says nothing when, for example, he keeps her from seeing any of the bills or takes out a loan in her name. In other words, coercive control is the framework that enables all coerced debt, including that generated by fraud or manipulation. Speaking of which, we have identified three main mechanisms of generating coerced debt. The first is fraud, right, which is using survivor's identity without their knowledge to obtain a loan or credit. This is able to happen because so much of our obtaining debt in our country and our market system depends on having someone's personal information. You can think of it as a form of intimate identity theft. Second is coercion, right? As I just described, in this situation, the coercion, the demand would be a demand to take out a loan or incur a debt, and the threat would could be any kind of consequence. And then finally, manipulation, which is deliberately managing conditions or information to lead the survivor to take on debt she would not have otherwise incurred. And I'll give examples of all of these. The next several slides are from the survey Adrienne mentioned that we conducted with the National Domestic Violence Hotline. One thing we asked about was fraud, and it was a basic question. Have you ever found out about debt or bills you owed that an intimate partner put in your name without you knowing? As you can see, more than a fifth of our callers said yes, and this is likely an undercount because callers who had not yet discovered the fraud would answer this question no. This question represents our framework for screening for debt generated entirely through coercion, right? There's the demand that you borrow money, right? An intimate partner convinced or pressured you to borrow money or buy something on credit when you didn't want to. And then the follow-up question is the threat of the consequence if she says no. we derived the screening from the DV literature's definition of coercive control. Here are results for coercion, breaking it down into the types of consequences. You can see the majority were psychological consequences, but more than a third were physical consequences, and a small number were financial threats. It's worth noting that many of the callers who cited physical consequences also mentioned psychological or financial ones, but coded those as physical for reasons I'll explain in a moment. So looking specifically, or looking at combining callers who had experienced coercion or fraud or both, we found that more than half of our sample met the criteria for one or both of those methods of generating coerced debt. If we only include the coercion with a threat of physical harm, it is still almost a third of the survey. One of our goals for this research is to develop data that will lay the groundwork for legal reform, which means in addition to considering how coercion is defined in the DV literature, we need to think about how the general legal community conceptualizes it. So here we've used physical violence as a proxy for legal duress, though we will be conducting a more fine-grained analysis. And again, you can see that nearly a third of the callers said yes to some form of coercive debt, even only using physical threats as the baseline for coercion. A final category of possible coerced debt that we found is debt generated from the abuser putting household bills in somebody's name, right, like the electricity bill or utility bills, and that the caller was left owing money on bills that had not been paid in time or in full. From the way we framed the question, right, whether an intimate partner convinced or pressured you to put the bills under your name, it sounds like this is not entirely voluntary debt, but we are calling it, the conservative calling it possibly coerced, because we did not have room in the survey to ask what might have happened if the caller said no. We don't know if there were consequences. Adrienne mentioned our other study in which we're conducting in-depth interviews with a much smaller number of coerced debt survivors. And here's where manipulation came through. We did not ask directly about manipulation in the hotline survey, but it came through loud and clear in our interviews. The text you have here is an excerpt from an interview with a woman who was a recent immigrant. Her abusive husband used physical abuse to establish coercive control and generate coerced debt, but he also used psychological manipulation, right? Things like taking advantage of her lack of knowledge of the U.S. consumer credit system, right? He's saying everybody does it, but just fine, and framing things so that he was doing her a favor, right? He's let me take the stress off you by not letting her have any information about how much debt was in her name. This quotation in the circled part also touches on the financial restriction of keeping financial information from the survivor, which I'll discuss next. Here, that took the form of not letting her see the mail or not letting her have a key to the mailbox, so she had no way to use documents to find out how much money she owed. This type of financial restriction was pervasive in both of our studies. You can see more than half in both our interviews and in our hotline survey, and very close to 3/4 in our hotline survey of respondents said yes to this question. Experiencing financial restriction is correlated with experiencing coerced debt, right? 61% experienced financial restriction, also experienced coerced debt. And this relationship was very strong, right? Women whose partners kept financial information from them were 3.5 times more likely to experience coerced debt. Now I'm going to turn it back over to Adrienne, who will discuss our findings on the effects of coerced debt.
Thanks, Angie. So in our research, we have focused our attention on 3 harmful effects of coerced debt: credit report problems, financial dependence, and financial hardship. I'm going to share a little about what we know about each of these things. So first, here's what we've learned about credit report problems from the National Hotline Survey. We asked respondents, has your credit report or credit score been hurt by the actions of an intimate partner? 46% said yes. And if you look there in the fine print in the bottom right-hand corner, another 14% said they weren't sure. So the number whose credit was hurt could be greater than 46%. When we look at the role of coerced debt, we found that women who had coerced debt were 8 times more likely than women without coerced debt to have their credit report or score hurt by their intimate partner. So this finding suggests that when a survivor's credit is hurt by an intimate partner, it's highly likely due to coerced debt. So onto the second harmful effect, financial dependence. It's widely understood. There's decades of evidence in the research literature about how abusers create financial dependence. As intended, the dependence really makes leaving an abusive relationship extremely difficult. So we wanted to ask the hotline callers about this. We asked, have you ever stayed longer than you wanted in a relationship with someone who was controlling because of concerns about financially supporting yourself or your children? And 73% of the callers said yes to that question. Not surprisingly, women with coerced debt were 2.3 times more likely than women without coerced debt to stay longer due to financial concerns. Now we asked a follow-up question to this. We asked a follow-up question, so anyone who said that they stayed longer because of financial concerns, we asked them, were any of your concerns about money you owed because your partner put bills in your name or convinced you to borrow it? And 41% said yes. So many of the women who stayed longer because of money were concerned about money they owed due to their abuser's actions. On to the third harmful consequence, financial hardship. This was a major theme in our in-depth interviews. We didn't ask about it in the National Hotline Survey. Again, we had limited space, but this came up over and over again in our in-depth interviews. For example, we had one woman that we interviewed. She had a great job. She owned her own home at the time that she met her husband. Over the course of their 8-year marriage, she lost her $65,000 a year job. She spent through her 401k, which had about $100,000 in it. They refinanced her home, and he spent the money they made off of that refinancing on a debt that he had from a prior marriage. And then she lost her house when it became unaffordable. Basically, her abuser had manipulated and threatened her to the point where until she was completely wiped out. She recalled finally at some point saying to him, "We went through every damn dime I have. We are done spending." Essentially, she was left with nothing. At the time that she was interviewed, she couldn't buy food, gas. She had debt she couldn't pay. She was incurring tons of interest and late fees on her debt. She was at the point where she was considering begging on the street for money to be able to pay her bills and to get by. So reflecting back on it all, this is what she had to say. I think what this could have looked like had I not married him, and the possibilities of where I could be financially and where I am now. I've always done a lot of volunteer work in my life. I used to go down to the soup kitchen in downtown Detroit before I met him once a month and help make sandwiches and soup and serve the people and stuff. And never once did I ever think that maybe that may be my future. Oops, let me skip So that woman's financial situation had changed dramatically as a result of her abuser's actions. And this is a quote from another woman who had a similar kind of experience, talking about, so here she's talking about life before and after her abusive marriage. She said, before the relationship, it was a different kind of stress. It was managing my finances without too much debt. It may have been check to check, but it was check to check without heavy debt. After, I was always stressed out, always a mess, constant anxiety, having a hard time sleeping at night, getting food from food banks, horrible haircuts, living like a low-income person, struggling. So again, this person was, she experienced a significant decline in her financial status as a result of her abuser's actions. Now, I'm sure that all of you could share similar stories of survivors you've worked with who experienced a decline in their financial situation because of their partner. This is a terrible and common problem that is compromising women's safety and overall well-being. So at this point, we are going to turn our attention away from the problem and start talking about identifying coerced debt. I'm going to turn it over to Angie.
Thank you, Adrienne. Yeah. What just happened?
Yeah. So, Angie, this is Erica, and I think that this is where I'm just going to pipe in a little bit about kind of framing the approach to the identification process and the implications for lawyers and advocates in the field addressing these issues. So when we're talking about moving forward with credit advocacy with the client, it's really critical to understand the survivor's current situation, the survivor's goals, and to develop a partnership with survivors. We think about advocacy for survivors of domestic violence, including advocacy in the consumer law realm, as taking place within the context of a survivor's broader safety plan. I sometimes talk about this in terms of an umbrella of safety. So this umbrella of safety planning helps us to see that any work that we do, whether it's legal work or non-legal work, is just one piece of an overarching safety plan for a particular person. So that for us as attorneys, the legal case cannot exist in a vacuum, but rather is just one safety strategy within a much broader and complex plan. To take another metaphor, we really need to understand the forest in order to tend to the trees. The trees in this case may be coerced debt. So for example, lawyers and advocates that are seeking financial information in order to address concerns must strategize with the survivor about how such information can be safely obtained. The strategies are going to depend upon the particular circumstances of an individual's life, and that type of safety planning has to be done in partnership with the survivor, which really means that creativity is critical to the process. Before moving forward with credit advocacy, we need to develop a partnership through honest and open communication about the legal process. So, we'll be talking today about some concrete legal remedies that are available, but of course, when we're thinking about all of these different legal remedies and options, we'll need to make sure that it's taking place in conversation with the survivor and in a way that's really assessing risk and benefits and is driven by the survivor herself. So, for example, sharing explicitly with the survivor the pros and cons of moving forward with different legal strategies, allowing the survivor to be engaged in the process, asking the survivor throughout the process, how does this sound to you? What are your concerns? How do you think your partner may react if we do X, Y, and Z? What are some things that we can do to decrease that risk? So, just because a risk exists doesn't mean that she's not going to avail herself of a particular strategy, but really engaging with her in thinking about risks, mitigation strategies and really analyzing whether or not they're useful in light of the risks that she faces. Other questions might be, given your concerns, do you still want to move forward? Who else can support you as we move through this process? And really talking with the survivor throughout the legal representation process about safety considerations and weaving them into your legal strategies. So in this particular slide here, we framed it in terms of first understanding what the overarching goals are as it relates to credit and debt advocacy, working with your client to assess and understand the full spectrum of survivors' risks, right? So in our work with survivors, we'll want to know much more broadly than just the debt and credit-related issues that she's facing, but really having a broader sense about what are the batterer-generated risks that she's facing in terms of physical abuse, but also risks to her children, health care, employment-related risks, as well as what are the life-generated risks that she faces. Life-generated risks are risks that are not related to somebody's partner necessarily, but are just part of a person's broader life concerns. They may be employment-related, health concerns, all sorts of risks stemming from poverty. And then weighing the risks and benefits of different legal options in light of a survivor's broader circumstances. So this is really where working in partnership is critical, because the survivor, of course, is bringing her expertise around her own life and the types of strategies that she's employed historically and what has worked, what hasn't, who are her allies. And we as lawyers and legal advocates are bringing our own expertise about the legal remedies available and about the ways that systems work, and as well as the perceptions of decision makers and how different strategies may play out in court. So it's that combination of expertise between survivor and attorney that are really critical in thinking together about the viability of different strategies and how they'll impact her broader safety plan and life plan. I also just want to mention that this work really does require a trauma-informed approach, whether we're talking about debt advocacy or really any other type of legal advocacy. It requires that we provide as much information as possible about the options, and that we, again, engage in a partnership that can enhance her experience. Just, related to that is that I think the need to recognize that asking survivors about financial abuse can be just as traumatizing as asking about physical or sexual abuse, because we're really talking about abuse. We're not simply talking about numbers. So what might seem like a straightforward discussion about debt to some people may feel to the survivor like examining scars or really even open wounds. This could be the first time that the survivor has made the connection between the abuser's actions and her own financial situation. So I think it really requires us to think about how do we frame these questions in ways that minimize the trauma? How do we minimize the shame that is often associated with debt in order to facilitate an advocacy relationship to engage the survivor in this type of work? And how do we support survivors with the resources that they need, regardless of whether she chooses to pursue a particular legal cause of action? There are lots of resources that we have to share with you about survivor-centered advocacy, as well as trauma-informed legal representation, and I see here that Sarah has provided some links. Okay, I'm going to turn it back to you, Angie.
Great, thank you, Erica. I will actually echo what you were saying about shame and debt. In my other research, I survey people filing for bankruptcy, and the shame that they feel is overwhelming. So yes, talking about finances can be stressful, no matter just in general, and adding the layer of abuse, of course, makes it even more traumatizing. So the process I'm about to outline is how we identified coerced debt in our interviews. We're presenting it because it may be a useful template that can be adapted to your advocacy or legal work. And yes, I just want to emphasize what Erica said, is you always want to keep safety as paramount as we do when we're implementing these, but I'm not going to mention it specifically. So the first thing we do is obtain somebody's credit report. Under federal law, all consumers are entitled to one free credit report per year from each of the 3 major credit bureaus. Make sure to use annualcreditreport.com. As the slide says, it's the only source for your free credit report. Don't use anything related to free credit report because that one is not actually free. So annual credit report or its phone number, which we have circled here. There are 3 major credit reporting agencies, Equifax, TransUnion, and Experian. They are likely to have vaguely similar but not necessarily identical information. If you want to be sure to catch everything, ask the survivor to order all 3, although that does mean that she cannot obtain another free one for 12 months unless she has been a victim of identity theft, in which case she isn't able to obtain additional free credit reports. So the process we use from here is to go through each item on the credit report and assess for fraud or coercion, right? So this is our fraud screening for loans taken out in her name, right? So first of all, do you recognize the account? And if not, that could have been taken out by fraud. And then if she does recognize it, listen to the circumstances surrounding the opening of the account and listen for fraudulent activity. We also screen for fraudulent use of existing credit cards, right? Because credit cards, even if she obtained it consensually, her partner could still use it fraudulently or through coercion. This is our screening for coerced loans taken out in her name, right? First, we ask her to describe the circumstances of opening the account, listening for any abuse or influence or demands. Then we ask her directly about the abuser's involvement in the decision. Again, listening for any demands that he made, and that's the demand part of our coerced debt. And finally, we ask, what did you think would happen if you said no? And that's our probe for consequences, listening for a threat of harm due to noncompliance. We did a similar screening for use of existing credit cards, because again, she could have taken out the credit card voluntarily, but then been forced to use it in a way that was coercive. Finally, we ask about debt that's not on the credit report for 2 reasons. First, credit reports are frequently inaccurate and incomplete, so there could be debt that's missing from it. And then second, creditors like payday lenders or rent-to-own stores don't report to the major credit bureaus, and so those debts would not necessarily be on somebody's credit report. So that is the end of Adrienne and my presentation, and we're going to pause for a moment to take your questions, which we're looking forward to answering, or to hear your comments.
Wonderful. So if folks would like to pose questions related to the content of what's been presented so far, we'd be happy to answer them right now. I know it sometimes takes a couple of minutes for folks to pull some questions together, so feel free to jot those into your chat box. In the meantime, I have sort of another question for participants to think about or share with us. So Angela had just mentioned the process of pulling credit reports, and of course, pulling a credit report in and of itself may pose safety and privacy concerns for survivors because it oftentimes will reveal the location of a survivor. So I'm just curious, in addition to any other questions that you might have, if folks wanted to share with us some strategies that you've employed to minimize some of these safety risks, which of course depend from person to person and the batterer's knowledge of her location. But, you know, are there strategies that you've employed in your credit-related and debt-related work to mitigate some of those risks? Feel free to share that with us.
And this is Sarah. Seeing a couple questions come in as folks are also thinking about their safety implications. Some are services related to credit repair, and we have a bunch of different training webinars and training slides and various resources that really help do a deep dive in that. So I would recommend that you check out our website and our resource library for a starting place there, and also let us know if there's any way we can assist. But if any of our faculty on the call has anything that you'd like to say about credit repair. There's also a question about checking in on things like payday loans, rent-a-center, and some things that might not appear on reports. What might be an approach to assessing some of that with survivors?
And we ask or Adrienne, this is Angie, we can jump in here too. I mean, we sort of have a list of what we ask, right? Are there any, first we just ask generally, is there anything on your credit report that you can think of that's not in your credit report? And then we kind of go through the list, right? Any payday loans that you know about, any rent-to-own loans that you know about, any ordering on credit from catalogs that you know about, and that kind of thing. I will also say, no, go ahead.
No, go ahead.
Oh, I'll also say, and about the credit repair, that Adrienne and I can offer a big endorsement of the Center for Survivor Advocacy and Justice materials, because we use those as the resources that we give our participants at the end of an interview.
Yeah, and this is Matt. I have a quick rant about debt settlement, which clients also have sometimes questions about. Every debt settlement entity that I've seen has been a scam. I've never seen anyone benefit from being involved in a debt settlement or with a debt settlement agency. You know, oftentimes I see people getting sued even though they're involved with debt settlement. The debt settlement company is not paying money. Many fly-by-night debt settlements just sort of take everything and leave. So I always, you know, give clients a speech very similar to what I just gave, not to get involved with them, because there's a lot of expense and very little benefit to be gained from it. And the other thing I would say, just with relation to credit, is, you know, credit's important. It's important for finding a job. It's important for finding housing. But there, you know, a lot of times people, there's a lot of self-worth and ego wrapped up in the credit score, and you can really get in this cycle of feeling sort of bad about yourself, you know, if your credit's not improving or your credit's not good. And I, you know, always, you know, have a conversation with clients that, you know, that's not the case, right? That this is, you know, in a lot of respects a short-term picture of what's going on, and two, it's in, you know, that sort of thinking where you see it as a reflection on yourself is you know, not worth getting involved in, and really not true. So those are my 2 points.
This is Angie. I want to echo what Matt was saying about debt settlement. all the research shows that just about every company that does that is scam. And some of them list themselves as credit counseling as well, so beware of that too. Some credit counseling is legitimate, but others are not and are really just debt settlement companies.
And to that point, this is Sarah. I do know that I believe on the webinar with us are some of our partners that are financial assistance nonprofit agencies and credit financial coaching and assistance folks that do work with domestic violence agencies across the country and are familiar with the particular needs of survivors. And so those might be a good place to start and to figure out some safer or more appropriate and relevant options, one of which the financial clinic is a good partner of ours working in New York and elsewhere, and there are others. So feel free to ask around to attendees about what they can do around some of those issues.
I just want to comment on two things that have come up before we finish up our question session and then move to the next piece of our content. And so the issue of barriers to employment and housing stemming from credit are absolutely real for survivors of domestic violence. And we, if you're interested, we recently had a webinar that was related to employers' practices of credit checks and the barriers that is often presenting for survivors. Some interesting strategies both on the individual level and also in terms of more policy and systems change work. And then the other thing I just wanted to mention around pulling credit checks, I know some folks piped up with responses here, and I think somebody had suggested providing an alternate address when pulling credit reports. And in some instances, I know that domestic violence organizations or advocacy services are able to use either their address or a post office box can be provided. Other folks I know have talked about developing relations between domestic violence agencies and banking institutions because the banks are able to do a soft pull, which does not reveal the location. So again, it really is going to depend a lot on the particular safety risks that that survivor is facing.
Mm-hmm. And we also have, I was just going to say, Erica, we're getting some questions about particular defenses and how to talk about this, which I think in the legal context, which I think is a nice segue to holding some of these questions that are coming in, as I think Matt and Ariana are going to touch on them, and we can revisit some of these questions at the end.
Great. So let us then move to Matt and Ariana to talk about addressing coerced debt.
Okay, hi everyone. This is Ariana speaking now from MFY Legal Services. Matt and I are going to be talking about the addressing coerced debt portion of the presentation and trying to figure out how to take all of that, great, powerful information and research and present it to a potentially unsympathetic or just uninformed judge or perhaps like government official. So the three things that our legal advocacy portion are going to focus on are first the legal theory, so the framework in which these scenarios can be presented, the basically already existing legal frameworks that are out there, strategies for filling in gaps in those sorts in the already existing framework, and then also throughout we'll be addressing implications to safety and other concerns that survivors face as a particular client group. So in terms of legal theory, there are four, we've identified four basic frameworks in which these issues end up being presented in a legal case. And so one is identity theft. Identity theft can occur outside of the domestic violence context, but it's also, as was discussed, extremely prevalent in abusive relationships. Non-fraudulent coerced debt is sort of what we termed for the other aspect of coerced debt, where a survivor might have knowledge about what's going on, but that knowledge is overridden by threats of violence or actual violence. And bank account fraud is another aspect with its own sort of legal framework, and then there are also common law defenses and other concerns about impleading the abuser, which Matt's going to address separately. And so we wanted to start out because putting together these slides generated an interesting conversation among all the presenters about our knowledge that all of these instances of coerced debt arise out of an environment of coercion and violence, and yet the legal reality that identity theft already has a much more established, is much more established as a legal defense than what we're calling non-fraudulent coerced debt. So the main distinction between these two scenarios is the knowledge. In identity theft, the survivor generally isn't aware, has no knowledge, and hasn't given permission for her personal information to be used in order to obtain credit or for already existing credit accounts to be tampered with. Whereas with the non-fraudulent coerced debt, a survivor is aware of it, she knows about it, but the consent isn't being given freely because of the manipulative and violent abusive relationship that she has with the abuser. And so again, legally in dealing with judges, we're always really careful to separate these two because identity theft is a stronger tested defense in the law. So we are very careful to make sure that even though we know that it's coerced, to discuss it in a way that doesn't give any suggestion that the survivor knew about it and gave permission for it, because that can undermine the defenses that she would have available to her. So we were curious to know, in this interesting conversation that was generated among all of us, to know what sorts of labels the participants today use for addressing these sorts of debts and any strategies that you have for having this discussion. So terms that you found helpful and any other concerns that you would have with the terminology that we're using today. We definitely love to hear your feedback about that. So I'm going to be addressing identity theft, and the basic factual, fact pattern of an identity theft case is that an abuser uses a survivor's social security number and other identifying information to obtain credit in her name without her knowledge or permission. Often, as was discussed in the manipulation section, he will intercept and control the mail so that she either doesn't find out, never finds out about the account, or finds out about the account, too late when it's already delinquent. And we've seen, it's the most common problem is that people often find out about these accounts years later when they're reviewing their credit report, when they're sued, or even worse, as is I think probably most common, at least in New York, when their bank account is frozen or their wages are garnished after a judgment was entered without them even knowing that they've been sued. And this sort of harks back to what Angie was saying about credit reporting and how credit reports don't list things like payday loans, rent-to-sender accounts, and how credit is so important, and yet each credit report from each of the 3 major credit reporting agencies is going to have different information on it. So it's a very imperfect system, and often a lot of times accounts that are out there slip through the cracks. And then also the documents supporting the accounts are pretty shoddy, so that can mean that people are also being pursued for invalid accounts or pursued by multiple collectors for the same account. So we thought it might be helpful to demonstrate the identity theft fact pattern with an actual client example. A client we're calling Rachel is meeting with a credit counselor to review her credit report because she's looking for new housing, and her applications keep getting denied because of her credit. She's a DV survivor who escaped her abuser 6 years ago. She only has 1 credit card and a few student loans. In spite of this, her credit report shows 20 credit cards in her name and 3 judgments, many of them recent. She does not recognize any of the accounts. And generally, for anyone who's pulled a credit report online with someone, you know, the credit reporting agencies will ask a series of questions based on information on the report in order to verify that that the person who's pulling it is actually the person whose credit file it is. And the sinking feeling that you get when the answer to every single question is none of the above because the person doesn't recognize the account is kind of the first sign that there might be a deeper identity theft problem going on there. And so in terms of once you have this realization that a survivor has been the victim of identity theft, there are some protections that can be taken. We included here that FTC has actually a really great user-friendly report. They have it in English and in Spanish called Taking Charge. And that does a really excellent job of just laying out the steps that need to be taken, the numbers that need to be called in order to take advantage of these rights that exist for identity theft victims. So the first option, and I would say the easiest to access, is the fraud alert. So once someone gets the inkling that they might be an identity theft victim, the first thing they might want to do is just put on a fraud alert on their file. They can do an initial one that will last 90 days or an extended one that will last 7 years. And what the fraud alert means is just that a creditor will have to take additional steps in order to verify their identity before extending credit in their name. So it might result in a denial and then a follow-up call seeking more identifying information from the person who's seeking credit. So it's a little vague what these additional steps are. So it's not necessarily going to be completely effective in preventing new accounts from being opened, but I think the biggest advantage of doing the fraud alert is the evidentiary value, which means that years later, if someone ends up getting sued for an account, they now have a record of the fact that they were an identity theft victim that was created before the fact of that particular account that they're dealing with. The security freeze is much more protective, but it is also can be a little bit risky in some ways. So what a security freeze means is that the entire credit file is frozen, which means that nobody can take out credit under that person's name. So it's great because it's foolproof, you know, to the extent that it works in preventing new fraudulent accounts from being opened, but it's also going to prevent the actual consumer from opening accounts in her own name. And if she needs access to credit in order to gain financial independence, then that's going to be a real problem. So what you'd have to do is lift the freeze, and that requires remembering a PIN number. So if someone is got a lot going on, they're moving around a lot, it's essential that they remember that PIN or they're basically going to be blocked out of their own credit file. Now, we've already discussed accessing credit reports. Mail can sometimes be more effective when someone is an identity theft victim and can't access them online because they can't answer those security questions that I had mentioned. Once someone has their report and realizes that they've been an identity theft victim, they can put together an affidavit, which is, you know, just a sworn statement. The FTC has a sample identity theft affidavit online, where it's just their sworn account that they are an identity theft victim. And if they're able to get a law enforcement report, that identity theft affidavit together with the law enforcement report is going to be considered an identity theft report. And what having that identity theft report will entitle the consumer and ID theft victim to more rights under the Fair Credit Reporting Act, like, for example, rights to block fraudulent information, which is a stronger right than simply disputing the information. And once they have that identity theft report, that document can then be used to dispute accounts either through the credit reporting agencies or directly with the creditors and debt buyers, and even to do both. The issue about the difficulties of getting police reports and law enforcement reports, we're going to address a little bit more in detail later on, but I think everyone who's worked with identity theft victims knows that it can be extraordinarily difficult to get the law enforcement report. So that means that you might not be entitled to the right to block the information. You can still, however, fill out the identity theft affidavit, and there is a portion of that where you can note that the person tried to get a police report and wasn't able to. And I generally will counsel my clients to just take as many details as they can when they go to the precinct, what time they went, who they spoke with, what exactly they were told, all of the steps they did to follow up with that, and the continued refusal to provide a report documenting the incidents. So in terms of the identity theft defense, identity theft, is a complete defense to a debt collection lawsuit. In terms of there's, the common law contract-based arguments that had already existed involve like formation issues, that there was no contract actually formed between the consumer and the credit reporting agency. Fraud is kind of, the common law defenses were sort of ineffective in a lot of ways to dealing with debt collection lawsuits. Fraud, for example, has always arisen in the context of being defrauded by the other party to the contract, not by a third party such as an abusive partner. So, luckily the Truth in Lending Act is a federal statute that directly addresses the issue of identity theft in terms of unauthorized use of an account. So the TILA has now created a much clearer defense that wasn't quite so obvious in the common law before then. So the Truth in Lending Act does define unauthorized use as use of a credit card by a person other than the cardholder who does not have actual, implied, or apparent authority for such use, and from which the cardholder receives no benefit. We have an example here of unauthorized use in the terms of tampering with an already existing account. So identity theft, as I mentioned before, can be applying for a new credit card or tampering with an already existing card. And either situation would qualify as unauthorized use if the consumer didn't know about it and didn't give her permission for the use. So TILA, limits liability for unauthorized use. There is sort of a limit to that limit. Liability is limited to $50 if the issuer meets certain conditions. And these conditions generally focus around certain notifications provided to the consumer. Now, generally, the credit card companies won't actually try to hold the person responsible for the $50. In our experience, they'll just make them not liable. But in theory, a credit card company could hold an identity theft victim responsible for $50 of the unauthorized use, assuming those conditions were met. Fortunately, one of those conditions is that it's an accepted card, which means one that the consumer has requested and received, signed, used, or authorized another to use. So that would exclude a situation where the card was actually fraudulently applied for. The argument would be that that card is not accepted. However, it would include a situation of tampering with an already existing card. And just one note is that the issuer does have the burden of proving that the use was authorized and that these conditions were met if they're seeking to hold the person liable for $50. So as mentioned, in the law, identity theft is a complete, strong, tested defense, but that doesn't mean that it's easy to get relief for identity theft victims. There are a whole lot of evidentiary concerns in all identity theft cases, and then an additional layer of evidentiary concerns in domestic violence, coerced debt, identity theft situations. I'll just run through them quickly because I do know people want to get to the next part of the presentation. But the first issue is that creditors are just suspicious of identity theft claims. Generally, they think people open credit cards, planning to pretend to be identity theft victims, run up a bill, and then claim identity theft as if that's a really easy way to get out of paying your debt and not an extremely difficult offense to get relief for. So there are these misconceptions. There are just general biases against domestic violence survivors, misconceptions that they're trying to retaliate against a partner, and that's why they're claiming identity theft. Those are common biases that my clients have heard. Similarly, sexist misconceptions that a man has the right to use his wife's Social Security number. That's something that police will commonly tell women who are identity theft victims and are seeking a police report. It's not true legally, but that doesn't mean that certain officers don't believe that and don't tell that to victims when they go into precincts trying to get police reports. There's a general difficulty of proving a negative, proving that you didn't open the account, especially when you have absolutely no information about it. And so I'm going to turn it to Matt now.
All right. Thank you, Ariana. So this is non-fraudulent coerced debt, which we mentioned before is sort of a placeholder, right? I mean, it's perhaps not the greatest term. There does seem to be something deeply fraudulent about these transactions, and it doesn't really capture sort of how bad they are, right? Whereas identity theft has sort of the crime of theft built into the title. So if you have any good ideas or any good suggestions, I think we'd all be really interested in hearing them. So what are we talking about? So this is a sort of a scenario where an abuser uses actual violence or the threat of violence, either explicit or implicit, to get the survivor to use their credit card, debit card, or credit for the abuser's benefit, right? So it's not as identity theft is very obvious, right? There's a taking there, or the client, the abuser's getting a credit card without the person's permission. This is a little bit doesn't fall as easily into that identity theft category. So what does an example of this look like? So this is a case we worked on. Sarah is getting calls from her credit card company that she for charges that she made but didn't pay, and they're for items purchased for her partner under the threat of violence. So we have, the client actually did use the card, but it was only because of this threat of violence. So the question then is, are there any protections? And I think the answer to that is yes, or at least there are certainly very good arguments that they are protected. The caveat with that is that there's not a lot of attorneys doing this work. The theories are sort of very heavily statutory and sort of buried in the comments to the statute. So they're a little bit untested, and they may not be obvious to judges, and there may not be, a large volume of case law that you're going to be able to cite. The good news is I think the statutory language is pretty good, so you will have that to rely on. The considerations when sort of working on the theories that I'm going to be talking about are a couple. One is you want to be sort of strategic about your in-court advocacy, right? As I said, these are untested, and we want to make sure that when we are presenting them to the court, that we're getting as good a decision as possible. So we really want to focus on good fact patterns and pushing theories in front of judges who will be receptive to them. Okay, so we're back in the Truth in Lending Act, right? And the unauthorized use provision that we talked about earlier. So the question is, what does it mean for use to be authorized? What does that actually entail? So there's two things to fall under unauthorized use. The cardholder can't receive a benefit, and there is actual implied or apparent, there's no actual implied or apparent authority, sorry about that, for the use. So in the example with Sarah, right, there was no benefit to her. She was buying the items for the abuser, so that box is checked. And then the question is, what's the authority here? So in evaluating actual implied or apparent authority, you're going to look to state law and sort of delve into your state's agency law. And it's really sort of mushy. It's not, a lot of universal rules. The cases sort of fall at various parts of the spectrum. Some very good, right, where this sort of use would not be actual implied or apparent authority. But I think the question is actually slightly easier than an exploration into agency, because the official comments for the Truth in Lending Act say that use is unauthorized if it involves a fraud or robbery. And I think that's the analogy that we need to be making in these cases, right? That what's going on here is no different than a robbery where you have violence or the threat of violence that is used to force the other person to use their credit for the benefit of another. You know, if that happened between strangers, I don't think that there would be any question that it would fall under the definition of robbery and under the unauthorized use provision. And I think that because the people know each other, has no bearing on that analysis. So I think the key here, and especially in practice, is to get your try and fit your fact pattern to the fraud and robbery definitions under this section, and that's really going to be where you have the most success. So how can you use this? You know, where is this going to come up? And it really comes up in 3 ways. So it can be used in court as an affirmative defense to a collection action. It can be used, the unauthorized use provisions of the Truth in Lending Act can be used in addressing pre-lawsuit debt collection. And you can also bring affirmative litigation in federal court. All right. And so just a couple of things. Generally, these all apply to the second 2 things I talked about, which are the debt collection advocacy and the federal litigation. So, in order to get the ball rolling with these provisions, you have to give notice to the bank in your pre-suit advocacy. So it can be in any form. You can write the bank, or you can just call them and tell them, or the credit card issuer. Once notice is given of the unauthorized use, the card issuer investigates. That investigation is typically limited to their own records. So basically they will review the account statements and see if they think the use looks authorized or not. They must provide the consumer with information about the investigation within certain time limits. And so in the pre-suit advocacy context, the best case scenario is the bank does this advocacy. They determine that the use was unauthorized, and you know, debt is wiped out, and that issue is taken care of. If the bank doesn't do a sufficient investigation, or if they say the use was unauthorized or was authorized even though it wasn't, there's liability that flows from that. It flows from the reasonableness of the investigation. So if you're thinking about, you know, setting this up as a case, which is a very complex decision, you want to talk about a lot with, you know, the survivor. You really want to have as much information about the unauthorized use as possible, so that the bank can really do an investigation, and if they don't do a good investigation, you can point out sort of where they failed. Okay, so as an affirmative defense, so this is, you know, citing the provision in, you know, your answer, and using it to defend a collection action. So the positives for this are, you know, it creates a triable issue of fact, you know, that will get the client past summary judgment, right? The use wasn't authorized, and, you know, these charges weren't for my benefit, and, you know, that will force the creditor into trial, in my opinion, on, you know, what charges were authorized and what the actual amount is. And in many cases, getting past summary judgment will be enough to have the case go away, because creditors don't want to, you know, have the expense of going to trial. It's not worth it to bring in a witness and have this inquiry. The negatives of this are that it requires the survivor to discuss the abuse, and there may be a time where there is a trial, and they'll have to get on the stand and talk about it. And that's a very serious thing, and it's something you want to have at the intake. You want to discuss with the survivor and have a very serious discussion about what that means, the safety implications of it, their comfort level with it, before going forward. And it's you know, one of the difficulties, you know, as a lawyer is clients often tell you what you want to hear. And you have to sort of be guarded against that, and really think about what's going to be in the best interest for the client. The other negative is that if you push on this idea, you know, it's untested, and you may get a result. So, you know, that just goes back to sort of being careful and choosing good fact patterns. Okay, so pre-lawsuit advocacy. This is, the client just has the debt. The bank may be calling them to collect on it, or they may not be doing anything, but they know it exists. So the positives about that, about pre-suit advocacy, are you can maybe resolve things without it becoming a civil court lawsuit. And the process of advocacy is relatively simple. It's just sending a letter that you help the client draft and mail. The negatives are, as I said before, it's a lot of the liability for the bank is based on the investigation. So you want to be able to give the bank a lot of information. There may be safety issues associated with getting the information. It can be a lot to get organized. The clients are often very busy. The consumer law issue will oftentimes be, the fifth most important thing going on. And it just may not be something that's able to come together. And as I said in the affirmative defense section, you want to have a real clear conversation about safety and what your advocacy means with respect to that. The other thing is you only have a year to sue under the Truth in Lending Act. So the advocacy has to be done, pretty quickly, pretty close to the time of the fraud.
I just
okay.
want to quickly, if I could just really quickly pipe in about that. I think the timing piece of it that Matt is highlighting presents a particular challenge and an opportunity for lawyers and advocates to be working together, because given the fact that that type of advocacy must be done close to the time of the fraudulent behavior, it's also quite likely that the relationship has either just ended or is ongoing and can present a really high risk of retaliatory violence for somebody to be engaging in this kind of litigation. That doesn't mean it shouldn't happen, but it should absolutely be done with really thoughtful strategies to address those risks.
That's absolutely right. So we're going to move on to litigation in federal court. So this is, suing the bank for essentially failing to do a good investigation. And this is, a strategy that you're going to want to be sort of pretty judicious about. It has to be, a client that has an appetite for the litigation, that is, has no safety concerns, and that you feel comfortable moving forward with from a fact pattern perspective. So what are the positives? So litigation in federal court can be fun. So that's a little flip, right? It's fun for attorneys. It's a lot for clients. But what I would say is it's not family court. It's not the client is the person suing somebody. The person they're suing is a bank. So it's not oftentimes as bad as sort of those scenarios, although there are certainly lots of stress that can come with it. And there's also the opportunity to make good law, which is exciting. The other benefits are, when you sue a bank, it lets them know that you're serious. And, usually one of the things they say to you after the case is done is, hey, here's the card of, somebody at the bank that can take care of this next time, so you don't have to take us to court. And it can be beneficial for future clients. The other thing is you can get real money for your clients. There are damages, there are actual damages, and statutory damages, and we've had cases where we've gotten very significant awards for our clients. So the negatives, again, it's the short statute of limitations. You maybe only have a year to do this, or you definitely only have a year to do this. And the liability has to flow from the bad investigation, so there's a lot of advocacy on that end. It requires a commitment from the client. So, as I said before, our clients have a lot going on. The judiciary is not receptive or understanding of that. And they're going to expect a client to be there for a settlement conference, even if their kid gets sick that day. So that's a conversation you want to have. right? There's all sorts of problems with that way of thinking, but it's something you're going to have to confront, and it's a conversation you're going to want to have with the client at the intake. Okay, and the other concern is that you may make terrible law, but you know, we have that concern in every case. Okay, so the next thing is the Fair Credit Billing Act is very similar to the unauthorized use provision in terms of the investigation requirements and the liability limits. It's for billing errors, but there is some overlap for unauthorized use within it. And one of the nice things about the Fair Credit Billing Act is that it offers protection from unauthorized use that you benefit from. So you don't have to fit that second prong. There's a timing requirement for disputes under the Fair Billing Act, which create, you know, some issues that we've touched on earlier that Erica just mentioned with, you know, alerting the abuser that you're, you know, disputing things, or all sorts of safety implications. They have to be done within 60 days of getting the billing statement that shows the unauthorized use. So that's the timing requirement. The 60-day rule is a little bit fuzzier than that. There's an exception if you have sort of a good excuse for not filing the dispute within 60 days. So the practice tip there, file the dispute, is really, it refers to that 60-day limit. That is, if the client comes in, you know, 6 months later, a year later, send in the dispute, and then you can have a conversation with the bank about whether you fit in one of the exceptions. The Electronic Funds Transfers Act. So this is just the same as TILA, except it applies to debit cards. And there are a couple of important differences. It's the unauthorized use is prohibited, but a bit different. For debit card abuse or unauthorized use, it's only actual authority that matters. There's no requirement regarding implied or apparent authority. So it's really the robbery example is even more clear for debit card uses. I mean, that is going to, you know, the coerced debit card use is going to be, I think, very clearly unauthorized use under the Electronic Funds Transfers Act. Okay. And it's you know, a lot of the same rules regarding liability and timing. One thing that is important to note that you're protected under EFTA even if you're negligent, right? So if you write your PIN number on a piece of paper and keep it next to your card, and someone uses that card, the fact that your PIN number was nearby or, you know, in the same area isn't going to affect whether or not it's unauthorized use done under the Electronic Fund Transfers Act. Okay, and then I'm just going to want to quickly touch on common law defenses. So instinctually, it seems like something like duress should apply to these cases. And that is as a defense to a lawsuit that a creditor brings. But duress is only a defense if the contracting party is the one causing the direct or the duress. So in this case, the bank. And that's really never the case. The duress is coming from a third party. So even though instinctually it feels like this is something that should be available to our clients, it's not. And then in pleading, this is bringing in the abuser as a third party. You know, there may be some sense that that's helpful. I would never try something like that. I think that is, you know, I've never had a survivor that wanted to try that, and it means more sort of contact with them, and I think it's just a sort of bad strategy. So it's only in there to say, you know, don't do it. And then finally, Ariana and I and some other advocates are working with the CFPB to make clear that the type of fact pattern that we discuss here fits under the definition of unauthorized use. So we're trying to get some sort of additional guidance from the CFPB on that. So if you have any questions or want to share good cases with us or want to be involved in that effort, please let us know. And now I'm going to turn it back to Ariana.
Hi. I am not sure. I know we're past 2:30, so I'm going to let Sarah let me know if she wants me to continue with the PowerPoint.
Yeah, thank you. I'm gonna let you go ahead. I know that I'm gonna welcome folks to log off if they need to, but we are getting a lot of really interesting questions. We may not be able to answer them, but that is a signal to me that you're all very curious about this. So I'm gonna let Ariana finish up so we can get this recorded, and we'll make sure to get your questions answered in another format and give you all the recording when it's available. So go ahead, Ariana, and finish us up.
Okay, great. Thanks, Sarah. So actually, this last section about strategies should be fairly quick. We've covered some of it already. Our idea in having a strategy section was just to talk about ways to fill in the holes of an inadequate legal system and ways to prevent some of the abuse and harassment that survivors might be facing from debt collectors and from other parties that they need to interact with in order to resolve these problems in a non-outside of the courtroom way. So one thing, most of the times when clients call us, their main concern is harassment by debt collectors. And for survivors who are dealing with dozens and dozens of accounts that they may have recently learned about, they might be dealing with a lot of debt collection abuse. In that case, that's one area where the fact that they're moving around so much and changing their contact information so much is actually helpful to them, because I think sometimes the debt collectors are maybe a few steps behind in terms of their current contact information. But if that's not the case, it's always important to let them know whether their income is exempt. So for example, if someone has disability benefits or is on public assistance, that's likely to be exempt. I mean, Social Security disability is always exempt from collection by private collectors, and state benefits, will depend on the law of your states, but I think that's a fairly common protection. So just knowing that that source of income can't be taken, even if a collector sues them and even if a collector gets a judgment against them, provides a huge source of relief and peace, and is crucial information in making an informed decision about how to deal with the actual accounts. The next thing that's important for people to know about, and particularly survivors dealing with dozens of accounts that are the result of coerced debt, are the protections under the Federal Fair Debt Collection Practices Act. So this only applies to third-party debt collectors, so not to the originating creditors, but there'll be rights to dispute the debt, to request verification. Those rights are extremely important when a survivor didn't know about the account's existence or was, oh, I'm sorry, I'm not going through the PowerPoint as I'm talking about this. There we go. Those rights to dispute the debt and request verification are extremely important when a survivor either didn't know about the account or was prevented from getting regular statements and information because the mail was being intercepted by her abuser. So that'll just give some information about what the debt even is and how it originated. And then also the right to cease contact with a debt collector is another huge source of relief, and a lot of people don't realize that if they and particularly it's best to do in writing, but if they tell a debt collector to stop contacting them, they can only be contacted in certain very limited situations. There are also prohibitions against harassing and abusive communications, false and misleading communications, unfair practices, and third-party communications. So, that's really important for people to be aware of how far debt collection can go and what they should be facing. In addition, there are also often much more robust protections under state and local laws. The next strategy consideration is something that we addressed before, so I'll just talk about it briefly here. But getting a law enforcement report, which is really necessary to block information from your credit report and is almost becomes necessary as a practical matter in terms of defending against a debt collection case, can be extremely difficult, particularly for a survivor of domestic violence. So we've been, as Matt and I and other New York City advocates, and I'm sure advocates throughout the country, have been brainstorming on ways to engage law enforcement on the need to get these reports and the difficulty in getting these reports. And my understanding is that the real obstacle to their getting the reports are twofold. One is misinformation and bias, which we talked about already. And then the second is these are very difficult to solve cases, and they're bad for a local precinct's crime stats. And so that's another reason that they don't want to give out those reports. So in terms of other ways to get around that, some communities will have family justice centers that are domestic violence specific. I can't say that we've had that much more luck at them, unfortunately, but in your area it might be more helpful. Sometimes the district attorney's office will provide these law enforcement reports, though that can be a scary experience for a domestic violence survivor. She might not want to involve the district attorney's office, even more so than she might not want to involve the police. Also, some offices will require the filing of a criminal complaint. And Matt had a really great idea that, you know, just lodging the complaint in the report with the Federal Trade Commission should count as a law enforcement report because they are a law enforcement agency, and and so I think that is a really great argument to make. And the last thing is just with credit reports. I mean, this has already been addressed in the presentation, but they can be very difficult to access, particularly when you change your address frequently and don't know what accounts are actually listed on the report because you haven't seen it yet. And then there are also can be grave risks in accessing the reports because if you update your location information on it and your abuser knows your personal information and can access your report, he will be able to get all of that updated location information as well as employment information. So it can create very significant safety concerns. And New York City advocates have been reaching out to the Consumer Financial Protection Bureau to educate them about these problems and figure out alternative ways of accessing reports for domestic violence survivors so that can be done safely. And I think that's it for my portion of this.
Thank you, Ariana. Erica, I'm going to turn it to you to kind of close us out.
Absolutely. Yes, thank you, everybody. This last slide has survivors at the center of all of this, and it's really an overarching reminder for all of us of these strategies. All of the faculty today have referenced the need to consider each of the strategies in a very case-by-case analysis, and so this is a reminder of that. And if you're interested in some more resources related to client counseling from that perspective, we have those to provide, and we'll send them your way. Some resources from CSAJ oops, things happening with the slides. Okay. There are a number of resources that we've developed around economic justice more generally, as well as consumer rights related advocacy for survivors. So you can find all of the links to those resources here, whether it's our National Needs Assessment report, some of the reports coming out of our pilot and demonstration site work, as well as an assessment tool for organizations interested in doing this type of work. And then we have some specific resources related to debt and credit on this slide, which you'll be able to access later. Some previous trainings related to credit reporting and repair, another one related to debt prioritization and debt collection, and then a couple of other trainings that are related to credit and debt. Some upcoming trainings that we have around the corner on May 5th. We'll be joining Wider Opportunities for Women on a webinar related to, that's hosted by the Battered Women's Justice Project, that's related to economic relief and civil protection orders. And then on June 22nd, we have another webinar that we're hosting related to housing foreclosure and defense for domestic violence survivors. All of that information will be going out via our listserv, and you can also access it through our website.
And I just want to echo sorry, Erica, I just want to echo the foreclosure webinar. I know that a lot of folks joining us today were making those connections on the implications of credit and debt, and so this June webinar I think will be really valuable in continuing what are the longer term implications of this work. So I hope that folks will be able to join us for that in particular.
Yes, thank you. I want to mention a new project that was recently launched by the Center for Survivor Agency and Justice, and that is our Racial and Economic Equity of Survivors project. The goal of this new project is to really identify and address the systemic inequalities facing survivors of color. And we are engaged with a very diverse coalition of violence against women and race equity experts and advocates in the field. And all of the partners are listed here on this slide. And if you're interested in learning more about it or getting your community and organization involved, we hope that you'll reach out to us. So I want to thank everybody on this call today, the faculty absolutely for all of your expertise. This is, we hope, the beginning of some really exciting work that where we will be able to draw from the work being done around the country to address this need that survivors are so clearly facing. And so we do hope that you'll continue to be in touch with us about strategies that you're using within your community, as well as issues that you're coming up against. As Matt and Ariana discussed, they're engaged in some really exciting systems change work with the Consumer Financial Protection Bureau. So we'd love to be able to benefit and draw from all of your experiences on that front as well. Thanks, everybody, for participating today, and I believe you should have some emails already waiting for you. We hope you'll let us know your impressions from today and some future needs that you may have. I'm going to hand it back to Sarah.
Yeah, thank you. And just to echo that, thanks so much to the faculty and all participants for joining us today. You're really the experts on the ground, and the questions that came through, I want to acknowledge them and let you know that we'll kind of send them to our faculty and get some responses and include them with some of our follow-ups, so they will not go unanswered. And I'm also seeing some questions about the evaluation, and just to note, Erica mentioning kind of a coalition and collective effort, not only that Matt and Ariana are doing, but that CSAJ is engaged in with debt and various other consumer and issues facing survivors. In that evaluation, there's an opportunity that if you're interested in joining us, to please let us know, yes, no, or maybe so, as well as continue to ask us questions that you may have that arise from that came up today, or other experiences, and that will just pop up automatically as soon as you exit the webinar, or as soon as I kick us all off, which is what I'm going to do right now. So thanks again to everyone. We will be emailing you directly with links to the recording and slides, and please do not hesitate to reach out for further assistance. Thanks so much, and very happy weekend to you all.